parent, affiliates, or stations. VCMG Live is not responsible for any content, information, or opinions expressed. User bears full responsibility for their reliance on such content, information, or opinions.
Welcome to Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Sit back for the next half hour as host Steve-O interviews top experts in the fields of legal, health, financial, and home improvement. Steve-O offers such educational topics as community association law, family law, chiropractic care, employment law, healthcare law, and public insurance adjusting. Interviews by top experts in their field. And now, here's your host, Steve-O.
Good evening, South Florida. Welcome
this program
to another
Ask the
Expert show.
A listener must call into the radio station talk line and be a specific caller or answer a trivia question as specified by the show host to be awarded the prize. The contest duration is the length of the program itself. Winners may be limited to one winner per address and or phone number every 3 months. All listeners are eligible for prizes. Prizes do not exceed a value of $325. The prizes are provided by the show, and the delivery of the prizes is the sole responsibility of the program itself and not the radio station.
I was sorry about that. I was just getting ready to tell you how happy I am. First of all, we have Kaye Rembaum on tonight. It's of all of our market, it is our best show. We get more listeners writing about us. And just to put a little extra icing on the cake, we're going to give away a really nice restaurant gift certificate each half hour. And I promise you, these are going to be some really, really fine questions. We're going to break restaurants. We're going to break it down to Palm Beach, the first half, and then Broward, the second half. Kaye Rembaum wants to try to make everybody happy. And we've got, this is the first Thursday of the month. That means Kaye Rembaum. We've got board-certified attorney Robert Kaye. Good evening, Robert.
Good evening, Steve, and listeners. Welcome.
A lot of people cannot see this, but Robert's wearing a beautiful Kaye Bender shirt. Is that new?
No.
Okay. I didn't see mine in the mail. That's okay. Don't worry. It's okay. I wanted to tell you this. I don't know if word got back to you, but your show that was done last week, because you're also doing the last Thursday of the month also now, we got calls from Miami, we got calls from Vero Beach, we got calls from Port St. Lucie. Pretty amazing.
Well, a lot of good listeners to your stuff.
Yeah, so you know what, since it looks like we're getting a lot of new listeners, and by the way, if you'd like to call and you have a question, the boards are getting filled up as they always do. But if you've got a question for attorney Robert Kaye, give us a call right now at 888-565-1470. If you have a question about condo or HOA association law, give us a call here. And there's no such thing as a dumb question, because it's probably already been asked before. But Robert, since we have so many new people and the boards are filling up, 888-565-1470, tell everybody about Kaye Rembaum.
Well, Kaye Rembaum is a full-service law firm focusing our practice on the area of community association law, condominiums, homeowner associations, cooperatives. We operate out of our offices in Pompano Beach, Palm Beach Gardens, Tampa, and starting in this month, Orlando.
Yay.
Alan Schwartzide has joined the firm and is getting geared up in Orlando. We don't have the actual office space up and running yet, but Alan is functional and providing association legal services. We do whatever associations need. We review governing documents, advise as to rights and responsibilities of the board, of the various unit owners, dealing covenant violations, collection of unpaid maintenance assessments, contract negotiation, construction defect, complex construction defect litigation, pretty much across the board, anything an association deals with on a day-to-day basis, we do and provide those services.
Well, I got to tell you, Kaye Bender Rembaum has been with the Ask the Expert show for going on 5 years. It is without a doubt one of our most popular shows by the participation with the listeners, and we just get a lot of letters just saying how much they love the show, and it's only an hour show, but it really takes time away. And Kaye Bender Rembaum is more than happy to educate people about association law. We're going to go to the phones. They're all tied up. We've got Edward in Palm Beach first. Good evening, Edward.
Yes, hello. Can you hear me?
Do you have a question for Robert?
Yes. We have a HOA with a declaration and bylaws. The declaration provides for a fine of $25. But to amend the declaration, you need a 75% vote. For the bylaws, you only need a 50% vote, which therefore it's easier to change the bylaws than the declaration. Can we raise the fine in the bylaws?
Well, you say the $25 is in the declaration already?
Yes.
Well, unfortunately, if you put a higher number in the bylaws, you would have a conflict between those two documents. And under Florida law, when there's a conflict between the declaration and the bylaws, the provision of the declaration will prevail. So while you'll have the higher number in the bylaws, unfortunately, the declaration is the one that still controls. So what you may consider doing, if you think you can ever get that 75% one time, you propose an amendment to the declaration that reduces that requirement from 75 to something more manageable, 2/3 or a majority, so that you'll be able to make changes to the declaration down the road. Then you'd only have to get that high number one time.
Yeah, it's very difficult to get that. We tried.
Oh, I know.
It took us 2 years. Yeah. But thank you for the information. Appreciate it.
Thanks,
All right,
Edward.
thanks for listening.
Let's go to Karen in Fort Lauderdale. Good evening, Karen.
Yes, good evening, Robert. Thank you for your time.
Hello.
Hello?
Go ahead.
Yes, good evening. My question is, I understand that we're able to put up for a unit owner vote to require that they upgrade their windows and sliding glass doors to impact sliders. Are we able to just limit that vote to just the sliders and not the windows, or is it all or nothing?
You can present it as one way or the other. That there's no requirement that it be both in the statute. These days, windows tend to be more popular than the other types of protections, but whatever works for your building is the way you should go.
Because we're doing concrete restoration, we're down to 2 holdouts, and everyone else has had hurricane sliders, but the rest of the windows for the other 50 units are just wind resistant to 150, and we were afraid if we put it up for a vote that we might have to do everything.
Sure. Well, it makes sense of what you're saying.
Okay, thank you so much. That's the perfect answer. I appreciate it.
Thank you,
Well,
Karen.
good luck.
We now have a line open at 888-565-1470. We're here with Robert Kaye, Kaye Bender Rembaum, Association Law, and we're going in order as the calls come in, so just be patient there. Let's go to, I was just talking about Vero Beach, Robert. Here's Douglas in Vero Beach. Good evening, Douglas.
Thank you, gentlemen, for your public service, as always. Our declaration in our HOA currently places some restriction on leasing of homes by owners, and I am aware of the new law that went into effect last July 1st that affects how an HOA can restrict those, giving us the ability to make it a little tougher, that is to increase the minimum requirement. And I'm aware that only, however, applies to existing owners that accept that upon themselves and future owners who, after sale. But the question has come up as to whether or not under Florida law would either us in an HOA or people in a condo association be able to, with sufficient votes, change their declaration so as to outright prohibit leasing going forward, understanding it would be grandfathered in. Can we completely prohibit it, or are we limited to just dealing with the minimum length of time, etc.? Thank you.
Well, thank you for the call and the question. Yes, you are able to propose an amendment that will completely prohibit leasing, and subject to the restrictions that you've outlined that the statute provides, that assuming your documents are written in a certain format, that it would apply to those who approve it and then those who acquire title after it's become effective. We've had many clients through the years that have done that, and there's nothing in the law that prohibits it. Now, on the issue of the leasing amendment, particularly in the HOAs, there is a legal concept that is also out there that could apply, that might require everyone to be subject to it, whether they voted for it or not. And that is what's known as the Kaufman language. You may have heard about that. Kaufman language is language that automatically incorporates substantive changes to the statutes into your governing documents without the requirement of amending. It's language that says that you're bound by the specific statute, for you 720 of Florida statutes, as it may be amended from time to time. If that language is not in your documents, then there's a legal argument, a very strong legal argument, that this substantive change to the statute that limits your ability to amend your documents in this way does not apply to you unless you do have that Kaufman language either now or input into your documents at a later time. So that's a little legal twist that some communities are considering as applicable to them.
I'm glad you raised that, Counselor. May I ask for clarification?
Sure.
I think we have Kaufman language in our HOA declaration, and I'm understanding you to say that if we do, we have the ability to incorporate the new, more burdensome or tighter restrictions on leasing. What it is you can, as you know, you can require a minimum lease. I think it's 6 months or even a year, as opposed to our declaration is a minimum of a month, I think. But I'm not sure. I'm not understanding if our declaration has that Kaufman language in, and I'm assuming we have to get the full 2/3 support to change it to the new minimum.
Yes, what my point was, if you do have the Kaufman language, then what's in the statute does apply. If you do not have the Kaufman language, there's a legal argument that it does not apply to your community. So typically, Kaufman language is not something that's in original documents. It's generally put in by amendment by the community at some later time. So you may want to look carefully to see if yours has it or not.
Sure, we're fairly new. We're like 3 or 4 years old, and I think I got it in there. My last question is, if I'm understanding you correctly, Counselor, is that if it's not in there, we can never benefit from the more recent passed legislation. Is that what you're saying?
Well, you would need to amend to incorporate it if you don't have the Kaufman language.
Sure.
It wouldn't automatically apply to you. You could get the benefit if you consider it a benefit. Some people consider that to be a detriment.
Well, no, I do appreciate that. But if the majority of our owners wanted to restrict leasing more so than the original declaration passed 3 or 4 years ago, to take advantage of the opportunities that legislation went into effect last July 1st. I was thinking, well, at most we just have to get everybody to vote for it, but I'm still a little puzzled if we could ever be able to benefit from the new legislation that went into effect last July 1st, or do we have to wait till past the Kaufman language and then we can benefit from the successor, the next legislation that's passed at some future point. Hope that
I might have muddied my point with you. The point was that the statute limits your ability on amending to being applicable to only those who vote in favor of it or who acquire title after the amendment is passed. What I'm suggesting is if you do not have the Kaufman language, then an amendment that's adopted by the owners would apply to everybody, whether they voted in favor of it or not.
Oh, okay. That's a subtle point, but very, very important, depending on which side of the issue you're on, right?
Exactly.
And you're quite kind to be so patient to hear out my follow-up questions. I hope it's been a benefit to everyone listening.
Yes, happy to do so. Thank you for
Douglas,
listening.
call back again. You're a good caller. We got to go to break, and everybody
We have
who's
so many things upcoming to talk about.
yes. And when we come back, first of all, don't go anywhere. We've got a board full of calls, 888-565-1470. We're going to go to break, and for the fifth caller to the show, and we've got a line open for just the restaurant. We're going to give away a gift certificate to one of the finest restaurants in Broward County in Coral Springs. You know Coral Springs, don't you?
I do, yes.
So first caller, 888-565-1470. I'm sorry, it's the fifth caller. We're just starting to do this now. It's just something we want. We don't have to give away gift certificates to get calls. It's just something we want to do. We'll be right back.
Kaye Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several Kaye Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. Kaye Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact Kaye Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
From time to time, this program engages in contesting for prize giveaways. A listener must call into the radio station talk line and be a specific caller or answer a trivia question as specified by the show host to be awarded the prize. The contest duration is the length of the program itself. Winners may be limited to one winner per address and or phone number every 3 months. All listeners are eligible for prizes. Prizes do not exceed a value of $325. The prizes are provided by the show, and the delivery of the prizes is the sole responsibility of the program itself and not the radio station.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we are back. I don't know if we had a winner or not. We'll have to check with Dan. He will let us know. We're going to go to, you have a lot going on the month of September. Let me just sneak one call in because there's a board full of callers here. Sydney and Pompano Beach. Good evening.
You have a lot going on. A lot.
I think it's
Sydney, lower your radio down.
There's a board full of callers here.
Okay.
There you go. Okay. Do you have a question for Robert?
Yes, I do. I was wondering if you get water damage from a condo above you, who is responsible for the damages? Is the condo above me responsible, or am I responsible?
Well, it can be a complicated situation. It depends first and foremost as to why the water leak happened, whether it was because the owner upstairs was negligent, or if it was just something that happens, as it happens in many buildings throughout the area. If the upstairs owner was not negligent that caused the water to flood into the lower unit, the responsibility provisions in the governing documents and the statutes outline who's responsible for what. Now, the association has some responsibility for, say, the perimeter drywall, floor, and ceiling, the unfinished portion of it. The unit owner, the damaged unit owner, can be responsible for the finishings, the paint, the wallpaper, the floor coverings, the cabinetry, and the similar item, personal property. And unit owners should have insurance to protect them for that. It's not mandatory, but it's a good idea to have. If, however, the upstairs owner was negligent, let's say they turned on their bathtub and left it going and it overflowed and it went on for a while, it caused the damages, then that owner is going to be responsible for the damages that followed that. I was going to say flowed from that, but that would be too much like the water issue that we're talking about. And it would have to be proved that the upstairs owner was negligent and that negligence was the direct cause of the damage that occurred, which sometimes can be difficult to do. So generally speaking, it tends to fall to the individual owners for their portion, the association for its portion, and the upstairs owner for his or her portion. Oftentimes the insurance companies cover it and then fight amongst themselves as to who's responsible for what, and then go after different parties as well. So the facts of the situation is ultimately going to dictate who's responsible.
Does that answer your question? Okay. I guess it did answer her question. Again, we have a board full of callers. You have a lot of stuff going on. Let's get that in first, and then we'll go back to the phones.
Okay. Well, let's start with September the 8th. We have a live presentation in St. Petersburg at the CAI Suncoast Chapter Breakfast Program from 8 a.m. to 12 noon at the Marriott Hotel at 12600 Roosevelt Boulevard in St. Petersburg through the Suncoast CAI. It's a legal Q&A panel which will include Sean Brown from our Tampa office. That's September the 8th at 8 a.m. till noon. Also on September the 8th at 12 noon to 2 p.m. on Zoom, Lisa McGill from Pompano will be doing the Condominium and HOA board member certification course. That's a double course for both condominium and HOAs. So it's going to cover a lot of things. There's some board certification, but no continuing education. We'll go with that. On September the 14th from 12 noon to 1:30 p.m., another Zoom will be a discussion on the Senate Bill 4D What now? Emphasis on structural integrity, reserves, and milestone inspections. Jeffrey Rembaum, you may have heard that name, he'll be providing that information, hosted by Peggy West at 12 noon to 1:30 p.m. on September the 14th. On September 21st, 9 a.m. to 10:30, there's a panel discussion also on Senate Bill 4D, condo and cooperative building safety via Zoom, hosted by Real Manage. One of the speakers there will be Lisa McGill from the Pompano office. There'll also be some managers and engineers participating. That's a Zoom at 9 a.m. to 10:30 on September 21st. Also on September 21st at 12 noon on Zoom, Navigating the Federal Fair Housing Act, Assistance, Animal, or Pet. Emily Gannon from Pompano Beach office will be providing instruction on that. There is continuing education for that as well. 12 noon to 1 p.m. on September 21st. On September 22nd, Expo season is upon us, and the CAI South Florida chapter will start it off at 9:30 to 4:15 at the Signature Grand in Davie. To register, you go to CAI-SEFLFlorida.org, CAISEFlorida.org, or go to our website, kbrlegal.com, and click on the calendar for events to do that. Now, in October, before our next show, on October 4th, there will be an expo in Palm Beach. That will be from 9 to 5 at the Palm Beach Convention Center. We're going to have 2 classes going at that particular one. Guest restrictions are at 9:30. The 2023 legal update, which is changes in the law from 2022, will be at 3 p.m. You register at pccondohoaexpo.com or go to kbrlegal.com to our calendar and click on the event and register that way.
Wow.
So that's a lot going on.
Busy. So we still have 2 callers, original callers from when we opened up.
Let's do it.
So let's go to George. George, where is Estero?
Estero's west.
Hello, it's Estero. It's Lee County, halfway between Fort Myers and Naples.
Okay.
Lovely area.
Yes, anyway, I live in an HOA, primarily single-family homes. We have an architectural review committee that has a nice booklet with regard to house paint, driveway colors, and some other things. But they don't have anything with regard to either solar panels or electric vehicle charging stations. And I've asked if they, in fact, even feel that they have jurisdiction over that, but I can't get an answer. So my concern is if I put up solar panels, I don't want them to come back and say, oh, no, you can't do that. Any suggestions? And again, when I say solar panels, I mean, roof solar panels for a single-family home.
Right.
Thank you.
Well, solar panels are protected in Florida statutes. I think it's in the 163 area, 160, somewhere around there. But community association documents cannot limit the ability to install energy-saving devices, which would include solar panels. The association specifications can have some limitations as to some appearance-related items, but they can't impede your ability to do that. So solar panels is something that the association would not be in a position to prohibit in your setting. In some condominium settings, there may be some issues dealing with common elements, but there's even been decisions that allowed for solar panels to be placed in condominiums, even though it's not the property of the owner that's installing it. So solar panels is something that is generally protected in Florida at the moment.
Thank you very much.
All
Thanks,
right, enjoy
George.
a stare.
You know what I could never do? We could never do stump the lawyer. You have never been stumped in 5 years. So we won't be able to stump the lawyer ever. Let's go to our next call who's been waiting for a while. Barry in Miami. Hi, Barry.
Yeah. Hi, Robert. Hi, Steve-O. How are you?
Good.
Good.
Thank you for waiting.
Sure. We have a declaration in a condominium that was adopted in 2002. We don't have Kaufman language. We do not have a fining provision. Can we still impose a fine?
Well, yes, you can. The statutes were amended, which is considered a procedural amendment, not a substantive one, to allow as a means of enforcement to implement a fining policy. Obviously, the fining procedure has to follow what the statute lays out, where the board identifies the violation, notifies the owners, and then there's a hearing before a fining committee made up of non-board members and no affiliates to board members to determine whether the fine is yes or no. And there's a limitation of $100 per incident up to a maximum of $1,000, with each day being a separate violation. And the fact that a fine cannot be an assessment or lien against the unit.
Has there been any DBPR ruling or cases that provide that it's a procedural provision and not a substantive provision?
To my knowledge, no. I don't think anybody has raised that issue through them or through the courts at this point.
Okay. Thank you very much.
Thanks, Barry. Number here is 888-565-1470, 888-565-1470. We're here with attorney, board certified, Robert Kaye of Kaye Bender Rembaum. We're going to go to break right now. Robert, give everybody the phone number at the office.
You can reach us at 800-974-0680, or you can write to us at info@kbrlegal.com, or you can go on our website, kbrlegal.com, and there's a contact box on the first page. Fill out your information, and someone will reach back to you.
And all the things you mentioned on the calendar for this month, they can find on your website also.
All on the website. Click on the calendar. It'll lay out all the events through the month, and click on the one you like or the multiple ones that you like and get registered.
We're going to do a break. We'll be right back with more. Ask the Experts, Kaye Bender Rembaum. We'll be right back.
Kaye Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several Kaye Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. Kaye Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact Kaye Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
From time to time, this program engages in contesting for prize giveaways. A listener must call into the radio station talk line and be a specific caller or answer a trivia question as specified by the show host to be awarded the prize. The contest duration is the length of the program itself. Winners may be limited to one winner per address and or phone number every 3 months. All listeners are eligible for prizes. Prizes do not exceed a value of $325. The prizes are provided by the show, and the delivery of the prizes is the sole responsibility of the program itself and not the radio station.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we're back. This is the Ask the Experts show. We're with you every Thursday night from 6 to 7. This is the first Thursday of the month. That means Kaye Bender Rembaum. We're here with board-certified Robert Kaye. And Robert, we're getting a lot of people wanting to know what is the purpose of DBPR. What does that stand for?
That's the Department of Business and Professional Regulation. It is one of the administrative agencies of the state of Florida, but it has a fairly wide umbrella of areas that it is involved in. I think from our listeners' perspective, their interest is how it relates to condominiums and homeowners associations. There's a division of condominiums that addresses condominiums, co-ops, mobile homes. I gave you the short name, and there is more to their name than condominiums. And it's created by statute that it oversees certain aspects of developer issues with respect to condominiums, some enforcement side of specific jurisdictional items for the division, that sometimes it tends to look at more broadly than others would like them to. And then there's education. A big part of what the division is supposed to do is to help educate the public as to the issues of the condominium law. For homeowners associations, the division jurisdiction is much more limited, dealing with election disputes through the arbitration section, and that's basically it. Maybe recall as well, but that's tied to elections. So for HOAs, the Department of Business and Regulation is really more an issue if there's a manager issue, because one of the professions that is regulated by the DBPR is property managers. There's a section that deals with just issues involving community property managers.
I want to go to Connie and Davy. She wants to know if we have money left at the end of the year, can we put it into the reserves? I think it should be given back to the owners.
Well, a lot depends on how they're structured with their budget. If there's been a vote of the owners to waive reserves, she doesn't say if she's a condominium or an HOA, so different laws will apply and different situations may apply depending on what they are. Generally, I view reserves for condominiums as there's statutory requirements as to what is supposed to be funded in reserves. And the board is required by the statute to fully fund the reserves with each budget. It does give the association and the board the option to present to the unit owners the question of whether or not to reduce what's going to be funded in a given year or completely waive them for the given year. And through the years, many have waived the reserves, and that's part of the reason there's been so much problem throughout the state, is that underfunded reserves mean that there isn't any money available for large expenses of renovations and repairs to the condominiums, and was one of the items that was pointed to with the building collapse last year. So the new legislation, as we know, has addressed some of that by eliminating the ability to waive structural type component reserves. There are certain things that the statute did not prohibit waiving, such as painting and paving, but anything that's structurally related, once the statutory provisions kick in at the end of next year, will not be waivable anymore. So if you have extra money in your budget, you have a statutory provision for reserves. It doesn't mean it's a slush fund. You just have extra money, you throw it into it. The association can create a miscellaneous or a line item that is like a reserve but not a reserve, in that it's not limited in how it can be used and only available for other purposes by a vote of the owners. Giving the money back is generally done not by sending everybody a check for their portion, but by reducing what is necessary for the next year's budget. and that way their monthly assessments would be something less.
Right. Okay. Bill in Boca says, my condo will have the first owners meeting this year. Owner has the right to attend such meetings, includes the right to speak at such meetings. Does this apply to renters?
Well, the answer to that is no. Owners have the right. Renters are not owners, so they don't have the right. Different boards view renters differently when it comes to meetings. Some communities invite everybody who lives there to come and encourages renters to participate. In many communities, you don't have to be an owner to be on the board. So a renter can be on the board, a renter can be the president in those types of communities. We've had clients that actually happened. So under the law, the entitlement is owners only. If the community through the board wants to make it more open, they can do that. They don't have to do that.
You know, I don't see how a condo or HOA association, the way things are, how they can ever deal without having a firm to represent them, that they can bounce things off of, that they can, because there's so many things. This is like running a big corporation, isn't it?
Absolutely is. That's exactly what it is. And some have budgets over $1 million and on an annual basis. So, you know, that's not a small amount of money for them to be dealing with. And honestly, the requirement of the board is to spend their money, not to save the money. You budget for what your expenses are and you collect money to cover them, then you use that money as you've budgeted. That's how the law intended it to work. We see many communities sometimes where the board members think that their job is to not spend money. But when that happens, we see that the physical aspect of the community can suffer when they're putting off repairs or putting off maintenance, putting off redecorations or freshenings, and then the places tend to get run down. So it is a good idea to be sure that you're adequately funding and then spending the money that you collect.
This is Gabriella in Aventura. Our board of directors blew the budget. They didn't factor in increases in cost. Now they have increased the monthly fees, but stated they are retroactive to the start of the year. Can they actually do that?
Actually, they can. The law requires the board to collect all the money necessary to properly operate and meet its obligations as they are laid out in the governing documents. And if the board made a mistake on the budget and underfunded and realizes the mistake in the middle of the year, they have the authority to redo the budget in the middle of the year. We recommend following the same procedures as the original adoption of the budget for condominiums, making sure you mail it out 14 days in advance, have a board meeting at which you're adopting the budget revision. HOAs, how your documents are structured relative to notice requirements for that is more the situation. And then calling it retroactive is one way of spreading it out, but really it's just being paid during the rest of the fiscal year of the community. So it's going to be a bigger bite.
Kelly in Delray wants to know, if a board member resigns, does the open seat have to be filled by the members that ran for the board but did not get elected?
No, that would be incorrect. If a board vacancy occurs, you look to your documents to see how it's filled, and most documents provide that it's filled by the remaining board members for the duration of the term that seat had. So for those that all the directors are the same year, then the seat would be filled by the board with whoever they choose for the remainder of the year. sometimes there's a staggered situation where the seat's open not for this upcoming year election, but the following year. So the seat would be filled until that happens. The board is not obligated to go to who ran for the board at the last election. They can choose whoever they want. They don't have to pick from any of those candidates if they choose. They pick from somebody that they believe they can work with. And that's an entitlement that they have. The majority of those remaining directors decide who it's going to be. And all they have to be is qualified under the documents and the law. They can't be a convicted felon without their civil rights restored for more than 5 years. And they can't be delinquent in assessments, but generally speaking, otherwise qualified. If the documents require a unit owner, then they'd be a unit owner. If not, they don't have to be.
You know, Robert, we get a lot of letters about towing cars away. Here's Stefan in Palm Beach. He wants to know, what authority does an HOA board have to tow cars parked on common area street? Do they need to post a 24-hour notice on the air, on the car, or just a notice in front of the HOA?
There's actually a statute specifically on point for the removal of vehicles from private property, which has been described in this question. I believe it's 715.07 of Florida statutes. In that statute, it requires there be certain signage in the community that identifies who's going to be the towing company and where they can be reached, and how it's supposed to be within a certain distance of the community. And that signage has to be located at the entrances. If there's multiple entrances that's not conducive, then it has to be located certain distances around the community. So assuming that the signage aspect is appropriately done, and the towing companies generally are who we look to make sure that the notice requirement is covered, then the issue is whether the vehicle violates something in the governing documents. It doesn't have to be in the driveway. It doesn't have to be on the lot in an HOA or in the person's park. Anywhere in the community, if the vehicle violates the governing documents, let's say there's a prohibition on pickup trucks, and it's a pickup truck, that could be towed. If there's a prohibition on a vehicle with expired tags, and it's got expired tags, even though it's on private property, it's on common area, it can be towed, assuming the other requirements of the statute are met.
Here's Kip in Hollywood. He said, I'm on the Rules and Regulations Committee at our condo. And by the way, we love these letters that come in, but just let us know if you are a condo or an HOA, because there are statutes that are different, and we don't want to just use generalities. So, and you're getting much better at it. But anyway, this is Kim in Hollywood on the Rules and Regulations Committee at her condo. It says, we are making recommendations to the board on updating them. Do we have to open our meetings up to the residents?
Well, the way the statutes deal with committees is that unless the bylaws provide for the ability to close those meetings, almost all committee meetings at which a quorum of the committee members are present are treated the same way as board meetings, where they have to be properly noticed and open to the unit owners to observe and participate. So the Rules Committee would fall into that same category.
Okay. Julian in Hallandale. Julian's in a condo. When can the association foreclose on an owner?
Well, that's going to depend on their documents as far as when an assessment becomes delinquent and subject to collection procedures of lien and foreclosure. Assuming that has triggered, sometimes it's 30 days, sometimes it's 10 days, sometimes 15. Different documents read differently. Then there's a series of requirements that the associations have to follow that the statutes have been amended through the years to require. The first, most recent one is that there has to be a 30-day notice from the association of its intent to turn the matter over to its attorney to pursue collections. And that notice has to be mailed and has to contain specific information that the statutes have outlined. Unfortunately, we've had many communities and management companies that prefer not to follow the specific statutory language, and we are of the opinion that you need to, in order to preserve the ability of the association to fully enforce its unpaid assessment. Once that has been done and the 30 days have gone, then the next requirement is that we send a 45-day notice of our intent to file a lien. So first they got 30 days, now they got 45 days. So we're at 75 days. After that 45 days, then we have to send another 45-day letter that says that we filed a lien. Here's a copy of what we filed. You now have 45 days to resolve this, or the matter's going to go to foreclosure. So then we've got 75 plus 45, that's roughly 120 days. So you're almost at many months before you can start foreclosing. At the expiration of all that time, if it hasn't been resolved, they haven't paid, then the foreclosure process can be started. A lawsuit is filed, the people have to be served by a process server, then there's 20 days to respond, and then the foreclosure process goes however long it takes, depending on the participation of the parties.
So people are given a lot of ample time.
Oh, a lot. But all the while, if they're not paying, the association still has its obligations to operate,
Right.
pay its bills, meet its obligations to its owners, and it becomes difficult. The more people that don't pay, the more difficult it is to operate, because everyone else has to make up that difference.
Well, I want to apologize about all the people on hold, but I do want to get in these text messages. Some of them are 3 and 4 weeks old because Robert's only with us once a month. I want to get, this is our last question of the evening. This is from Zach in Boca Raton. Loves your show. I have a question on safety and the law. Our pool has not been made to code for almost 2 years. Our inside pool lights have not worked. They've had at least one bid to fix it. Also, our gate is not properly working, and our license, if updated, has not been posted. It's been brought to our board's attention in writing continuously and at the board and the last annual meeting. Isn't this a safety negligence issue?
Well, it is a safety negligence issue, and it could rise to a level of more gross negligence, willful misconduct, if there's a serious injury that it can be tied to these lack of safety requirements being met, which could involve personal liability on the individual board members who have failed to take the necessary steps to meet the requirements of the code. Owners in that situation have choices, but they're not that great of choices. They can contact code enforcement and bring them out. The community could be cited, which costs everybody money, and they could be fined on a daily basis until they comply if the board continues to do that. Another option that they could consider is doing a recall of the board members who are failing to meet their fiduciary obligation and put in new people who would be willing to do what's necessary to resolve the issue within the community. The last option is to bring a lawsuit against the association and the board members for their failure to properly maintain the common areas.
We have come to an end of another Ask the Expert show. And again, keep sending your questions in. Let us know if you're a condo or an HOA. Give everybody the number at the office, Robert.
800-974-0680 will get you in contact with Pompano Beach, Palm Beach Gardens, Tampa, or Orlando. We also can be reached at kbrlegal.com. On the first page, there's the contact, or you can send an email to info@kbrlegal.com.
Well, thanks again. This is probably the most enjoyable show I do. We're going to be back with you next week at 6 p.m. with more Ask the Experts. Enjoy the holidays. Robert, have a good holiday.
Likewise.
We'll see you soon.
Thank you for tuning in today to Ask the Experts, sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Join host Steve-O again next Thursday for more interviews with the top experts in South Florida in the areas of legal, health, financial, and home improvement on Ask